on the speakers. Thank you, Mateo and Diane, for joining Don't Shoot Portland today to present a legal webinar on the moratorium, the eviction moratorium updates. These are statewide updates that affect all of us, especially residents of Multnomah County. So we really appreciate your time in making this happen today.
Well, thank you, Ty, for having us, and thank you, Findy, Teresa, and all of Don't Shoot Portland for always allowing us a platform to share this important information for tenants, right? So just real quick, I'm gonna try to share my screen here so you guys can see the PowerPoint that we organized. Make it easy to follow along. All right, so as Ty already mentioned, we're gonna be focusing on the COVID-19 tenant protections, the eviction moratorium that was recently passed to extend protections for tenants who are unable to pay, rent during this tremendously difficult time for tenants in, across Oregon. And by way of introduction, my name is Mateo Hermida. I am a housing paralegal and outreach worker with the Portland Regional Office of Legal Aid Services of Oregon. And I have my colleague Diane here with me as well, and I'll let her introduce herself.
Hey everyone, my name is Diane Nguyen, she, her pronouns. I'm a staff attorney with the Portland Regional Office of Legal Aid Services of Oregon. And like Mateo, my focus is on housing law where we represent tenants. Thank you for having us here today.
Awesome, thank you, Diane. And by the way, I use he, him pronouns, should have mentioned that initially. So yeah, I'm just gonna jump right in. We're gonna start with some of the highlights of House Bill 4401, which was the legislative act that extended the eviction moratorium across all of Oregon. And so, yeah, it's as you guys, some of you who may have seen the video of my last presentation, I did present on House Bill 4213, I believe it was, which was the prior moratorium that was in effect statewide, as well as the executive order that Governor Kate Brown had passed. I believe that was sometime in December. So there are a lot of similarities, and you guys will note that, but there are also some very important key differences that I just want to take note of, and that's what I have here on this highlights page. The first of these major differences is the sworn declaration of financial hardship. So this is a document that will largely determine who is protected by House Bill 4401 and for how long those protections will last for those tenants that submit this sworn declaration, and we'll get into more detail about that at a later time in a later slide. The next thing I want to note, of course, is when these protections expire. So the latest that they will expire will be June 30th of 2021. And then I want to also talk about the new landlord notice requirements. So unfortunately, non-payment notices were the most common cause of evictions across Oregon, if I'm not mistaken, before the pandemic started. So folks are probably familiar with, 72-hour notices of termination. Those are the typical notices that folks get when they're unable to pay rent. It's not, under the House Bill 4401, the notice requirement for landlords has been extended. So they have to provide tenants with a couple more days notice if they wish to terminate the tenancy due to non-payment of rent. So before it was 72 hours, now they have to at the very least provide 10 days. And we'll talk about that in more detail. The other thing I also want to note is that what we call landlord-based cause terminations are also permitted. We'll explain what those are. There are 4 different types. And then lastly, I also want to note the landlord compensation fund that was established under House Bill 4401. So basically, the legislature is making money available through OHCS to basically cover back rent for landlords who receive the sworn declaration from their tenants. So my understanding is that the state commits to setting up an application for landlords to utilize, and whoever applies, their application will be considered. And if they're approved, the state will cover 80% of the back rent that landlord is owed from tenants that submit the declaration of financial hardship. And then in exchange, they have to commit to cover the remaining 20% of that back rent. So basically, as we'll explain later in the presentation, it's in a tenant's best interest to submit the declaration of financial hardship to their landlord, because it creates the possibility for the landlord to apply for this financial assistance that might end up covering whatever back rent that tenant might owe. So who is protected and for how long? So like I said, this is largely dependent on whether or not a tenant submits the declaration of financial hardship. But the first thing to note is that, again, these protections apply statewide. They exist everywhere in Oregon. They're not just local. So as I was mentioning, this largely depends on whether or not a tenant gives the declaration of financial hardship. So renters who give their landlords that declaration will be protected up until June 30th of 2021. So they'll have until that date to pay back any money that they owe during the state of emergency. And just so you guys are aware, the state of emergency, or the emergency period, which we'll refer to a couple of times here in this presentation, is basically from April 1st of 2020 through, at that point, June 30th of 2021, if you submit the declaration. Renters who do not give their landlords a copy of the signed declaration will need to pay back any money that they owe from April 1st, 2020 through December 31st of 2020, so through the end of 2020, by March 31st of 2021. So they get that grace period, which might seem familiar to some of you guys because it was initially established by House Bill 4213. And then any rent that tenants that don't submit that declaration that is due after January 1st of 2021 and onward needs to be paid back on time in order to avoid eviction. The renter, if a renter is going to submit the declaration, it's important to note that they only need to give the declaration to their landlord once. So it's not required that the tenant submit one every month in order to be protected from eviction for non-payment during that month. The one declaration applies for the duration of the time that House Bill 4401 remains in effect. The financial hardship that the tenant is experiencing does not need to be related to the COVID-19 pandemic. So, if it was financial hardship caused by the wildfires, for example, a tenant that was affected by the wildfires could, in good faith, submit the declaration of financial hardship. And also if they encountered any other sort of financial hardship that wasn't necessarily related to the COVID-19 pandemic, as long as that statement of financial hardship is true, they could submit that declaration in good faith. And it is important to note that you shouldn't be submitting this declaration if it's not truthful, because there is a penalty of perjury if you submit an untruthful declaration. And then lastly, I also want to note that the landlords are not required to, or are not allowed to require additional information from tenants. So for example, a landlord can't be requiring you to submit like screenshots of your bank statements to prove that you're actually not having any income come in, right? The declaration is enough. That should be enough to protect you. I believe Diane is going to cover these slides.
Yeah. Actually, Mateo, if you can please go back to the last slide 1 second.
Yeah, absolutely.
Just to add some more, thank you, Mateo, for covering all of that. Just want to add a little more here is so that folks know that they have up until the date of first appearance, which is the first court date after if the landlord files the eviction case. The first appearance is the first date when the tenant has to appear at court, and the tenant has up until that date to, in court, hand the declaration, signed declaration to the landlord or their attorney, and it would still be effective. And the other thing to note is that there's only one declaration under the bill. Only one declaration is required per household or per tenancy. So if I live with a roommate who's on the same rental agreement and I submit a declaration, that would cover both of us. And thanks, Mateo. Okay, so what acts are prohibited under House Bill 4401? For folks who have been following the moratorium and law, this would seem very familiar because these prohibitions are similar to the previous moratorium, House Bill 4213. So just to review, things that landlords are not allowed to do under this moratorium is to give a termination notice for non-payment of rent, for unpaid fees or utilities or other charges. Landlords also cannot initiate, that is, file an eviction case, or if they had filed one, they cannot continue that case, they must dismiss that case if it's based on a non-payment termination notice. The exception here is if that non-payment notice was given before the emergency period. And like Mateo said, that emergency period started April 1st, 2020. So if that notice was given before April 1st, 2020, then under this moratorium, the landlord would still be able to pursue the eviction case. The landlord is also prohibited under this bill from interfering with a tenant's possession or use of the dwelling unit based on the fact that they didn't pay. And so the most common case, you would see something, for example, the landlord is threatening to lock out the tenant, physically evict them. Those would be interferences that could be shut off of water or other utilities. Landlord is also prohibited from charging late fees or penalties because of the non-payment. They are also prohibited from reporting the tenant's non-payment balance to a consumer credit reporting agency as delinquent. They're also not allowed to, for the most part, give no-cause termination notices. In the next slide, we'll discuss what Mateo had mentioned about the landlord-based terminations. Those are something that under this bill, it would be allowed, and we will go into that in the next slide. Under the moratorium, though, right now, the landlord is prohibited from initiating an eviction case based on a no-cause termination notice. So that is even if, as compared to the non-payment termination notice, bullet point 2 there, where if the notice was given before the emergency period, they can still evict. With a no-cause termination notice, even if that notice had been given before the emergency period, they cannot file that case now. And lastly, this is a slight change from the previous moratorium. Here it clarifies that the landlord also cannot file an action to recover the non-payment balance. So under the previous moratorium, there might be a little, it might be a little vague whether or not the landlord, okay, I can't evict you even though you did not pay rent, but I am going to sue you in court to recover that rent. Under this moratorium, the law makes clear that the landlord cannot file any action or sue the tenant to recover that amount. And they cannot do any of that, and they also cannot threaten to do any of that. Next slide, please. Okay, so what evictions are not prohibited? There are the 4-cause evictions. So other than not paying rent, a tenant is required to comply with all other terms of their rental agreement and with landlord-tenant law. The landlord-based causes are the exceptions here where, for the most part, a landlord cannot evict based on, for no cause, but these landlord-based causes are exceptions for which they can be evicted. So first here, you've got if the landlord is intending within a reasonable amount of time to demolish the unit, or if they're going to use the unit for a non-residential use. Second is if the landlord intends to make repairs or renovations that would cause a property to be unsafe to live in. The third is if the landlord or an immediate family member is planning to move into that unit and to use that unit as their primary residence. And the fourth here is if the landlord is selling that unit and the buyer is planning to move into that unit to use it as their primary residence. And for these notices, if the landlord issues this notice, they must give at least 90 days notice for the notice to be effective.
I don't know why it's not letting me. There we go. And the other thing to note is on top of the 90-day notice requirement, also depending on the size or the number of units that the landlord owns, there might also be an entitlement to relocation assistance if you get a 90-day notice that's based on a landlord-based cause termination, like those that Diane just outlined. So yeah, if you get that kind of notice, at the very least, I would encourage you to speak to a lawyer to see if maybe you have that potential entitlement to relocation assistance, because it's something that landlords very conveniently forget oftentimes. Thank you, Diane, for going through that. And then we also want to discuss those new landlord obligations. So like I mentioned, House Bill 4401 extends the notice period for non-payment from the 72 hours that we've all become very unfortunately familiar with to 10 days. So that's quite a bit more time for tenants to not only figure out how to pay the rent if they're able to, but also for them to submit that declaration, because when a landlord presents a tenant with a non-payment of rent termination notice during this emergency period established by House Bill 4401, they also need to provide a copy of the blank declaration for the renter to sign if the renter is unable to pay back rent because of financial hardship. And they also need to include a notice of the tenant's rights under the moratorium under House Bill 4401. So basically, tenants are provided a few more days of notice before the tenancy technically terminates. And they're also given an opportunity to submit that declaration if, let's say, they just weren't aware of the protections that were provided to them under the moratorium. And like Diane previously said, tenants will have until the date of their first appearance, which would be that first court date that they would be assigned if the landlord were to file an eviction case against them based on that non-payment notice. They would have until that hearing date to submit the declaration. So literally till like the last minute to submit it. Plenty of opportunities to do so, assuming that you can truthfully submit the declaration, of course. So what if a landlord violates the moratorium? So there are penalties under House Bill 4401 for landlords that don't comply with their obligations and the prohibitions established by House Bill 4401. So renters can sue the landlord for a penalty of up to 3 months of rent plus actual damages. So actual damages come into play when, let's say, for example, a tenant moves out under the belief that they're going to be evicted or they're locked out or something like that, and they end up, let's say, for example, having to pay for a motel or a hotel, right? Those are expenses that came out as a result of that violation of the moratorium, and potentially could be recoverable damages that the tenant could sue for. In addition to that, if a landlord evicts a renter in violation of the moratorium, locks the renter out, turns off the utilities to force the renter out, which we call an ouster. The renter can also go to court to get an order that will force the landlord to allow them back into their home.
So Mateo had covered this earlier on, but I think it's always helpful to have a visual. So this something Mateo put together is very helpfully here. So start with the question: has this tenant signed a declaration of financial hardship? If yes, then all their rent from April 1st, 2020 through June 30, 2021 will become due on June 30, 2021. Now, if the tenant has not signed the declaration, then the rent that became due from April 1st to December 31st, 2020 will all become due on March 31st, 2021. And for all rent that became due January 1st, 2021 onward, that the tenant is required to pay pursuant to their regular rental agreement. And this information was also partially covered earlier on, but the incentive for House Bill 4401, what it provides is that it created what's called a landlord distribution fund. Under that, as Mateo said earlier, the landlord can apply with the state to have up to 80% of the rent that is back rent that is owed by their tenants who have submitted to them a declaration of financial hardship. They can apply to have 80% of that back rent compensated by the state under the agreement that they will forgive the remaining 20%. And if they do apply for that, there's a requirement that notice is provided to the tenant, so the tenant would know that they had that rent had been paid by the state and the remaining 20% has been forgiven. And for renters, the first and best place to start with finding out what kind of rental assistance they might qualify for is to contact the 211 info line, which knows more about what sort of community resources there are, and depending on the needs of and eligibility of that particular caller, 211 would be the best place to triage and provide some referrals for the renter. And these are two links that we wanted to provide for folks. The first is the court website. The courts.oregon.gov, you log into that, put in that website, one of the first pop-ups you'll see is that alerts and emergency closures. Right there will be links to the English language declaration form. There will also be links to the Spanish, Russian, Vietnamese, Chinese, and Korean forms. The thing to note with the bill is that it provides that a tenant can submit a declaration form that is substantially in the form of the language that's provided in the sample form here. So technically it says substantially, it can be a different form, but tenants would be best advised to just use the form that's readily available and that uses the language as exactly as it is in the bill. As for the non-English languages here, the bill provides that the tenant must use the form that is provided by the courts. So that's why I want to highlight here that there are these forms available in other languages. And if a tenant is using a form in one of these other languages, they must use the one that's provided by the court. For folks who speak languages and write languages that are not covered here, it would be best if they have a form that is translated into their own language and submit both that form and the landlord's or the English language form to the landlord. And the second link that we have here is to a website that is maintained by our office, OregonRentersRights.org. You go to that /coronavirus there, you'll see that is a screenshot from our website that contains more information, a shorter video than the one that we're providing here today, and then also explainers in Spanish, Russian, Chinese, and Vietnamese on the moratorium.
Awesome. Stop sharing. And one other thing that we forgot to note and that I just quickly wanted to highlight is the CDC's eviction moratorium, which was recently extended by President Biden. So before, the CDC moratorium, we mostly ignored it because we have stronger protections here in Oregon, or did up until very recently. But the CDC moratorium, we feel, might become relevant in cases in which folks get those landlord-based cause termination notices, or even in cases in which somebody is being evicted as a result of a non-payment of termination notice that was presented to them before the emergency period. So let's say, for example, you got one back in March of 2020, like Diane had already mentioned, a landlord is technically allowed to pursue eviction if that termination notice was issued before the state of emergency began. But there are some arguments that the CDC moratorium might cover tenants, even if they did receive a termination notice before then and they still haven't been evicted, as well as tenants who have received, those very unique landlord-based cause termination notices. So I guess my point is if you guys get any of those types of notices, or if your landlord is pursuing eviction related to a termination notice that you received before the state of emergency began, contact legal aid or contact an attorney, contact some form of legal help. And, just to see, is there an argument here that I can't be evicted? And, whether it be us or the Oregon Law Center or some other tenant attorney, I'm sure that they would be happy to look into it and provide you guys, at the very least, some advice on the situation, right? So it's worth looking into and something worth keeping an eye out on. Because again, this is all very new to us. We don't know how judges would perceive that argument, but it is an argument and a potentially effective one. So just be mindful of it. And I believe that concludes our presentation. So again,
if I can.
Oh yeah, go ahead, Diane.
No, thank you for highlighting the CDC. I don't know if I should wait for Carly. Thank you, Mateo, for highlighting the CDC. I'll also highlight that for Multnomah County renters, we want to be really clear. Up until now, Multnomah County renters have had more protections than the rest of the state. But effective February 1st, the county is going to rescind its ordinance 1287. So everything that we discussed just now, just want to emphasize, before that, under the ordinance, Multnomah County renters automatically had those protections. Now, as with the rest of the state, renters will need to affirmatively sign that declaration and submit it if they are eligible in order to get that protection. And the other thing is, up until now, folks might have heard the term grace period, a 6-month grace period to repay the rent after the eviction moratorium period ends. There no longer is a 6-month grace period. So I just want to really highlight that and make sure that Multnomah County renters in particular understand that those additional protections are no longer effective as of, or on February 1st, they'll no longer be effective.
Thank you, Diane. Yeah, that's great to know. And on that topic, we have seen landlords in Multnomah County who have gotten confused by the news that that the county had rescinded its protections, and they assumed that that was effective immediately. So they've started to issue termination notices based on non-payment of rent. So if you've gotten a termination notice for non-payment of rent, from the beginning of the year through February 1st of 2021, and you're in Multnomah County, you might still be protected by the ordinance, because again, it's still in effect up until February 1st. So yeah, again, seek legal help if that's your case. And sorry, Findy, I'm pretty sure I cut you off.
No, it's cool. Yeah, it's funny though, because y'all are answering a lot of the questions just throughout as y'all are going through. Because have some questions about some of the acronyms that were used earlier about the Oregon Housing and Community Services. So thank y'all for including that in the slides as well, that information. I guess I just wanted to clarify for tenants, we talk about like tenants who may be ineligible for this. So it seems the only way that they will be ineligible is if there are those reasons that the landlord can like show cause, right? Like the 4 reasons. And I'm trying to think of another reason. What else would they would be ineligible to use this declaration outside if it wasn't in the emergency period? So we have the emergency period, and then we have like the 4 reasons that the landlord could technically terminate them. But outside of that, what would be some examples where they would be ineligible?
To submit the declaration?
Correct, yes.
Yeah, so I mean, if somebody, hadn't actually, suffered a loss of income, whether it be related to the COVID-19 pandemic or the wildfires or some other extenuating circumstance, they couldn't truthfully sign that declaration because it would be untrue. And like I said, I mean, if they were to submit that, it would be under penalty of perjury. So we definitely don't encourage somebody to submit the declaration just for the sake of doing so. It's really meant for folks who have been financially impacted under, this very difficult year and some change that we're now going into. So yeah, that's, I hope that answers your question. That's when somebody's not eligible to submit the declaration. And I don't know, Diane, you have something else to add?
Because probably my part of the presentation that got confusing, so thank you for this opportunity to do some clarifications. So essentially there are, for our purposes here, 3 types of termination notices. First is there's a non-payment termination notice. Second are the for-cause termination notices. And third are the what are no-cause termination notices that, and we're gonna refer to them here as the landlord-based ones. So for non-payment termination notices, like Mateo said, if a tenant has suffered any reduced income or increased expenses, then they can sign that declaration and get protection from being evicted for not paying rent. The for-cause terminations, those would be, for example, if I, as a tenant, harass the management staff of my apartment complex, I could be evicted based on what's called a for-cause termination notice, and that is not something that's protected by the moratorium. And third are the no-cause termination notices. For example, if my usual rental agreement is going to expire, my tenancy ends during this eviction moratorium time period, I would be protected from the landlord evicting me based on it having expired under normal terms of the lease during the moratorium. However, the no-cause termination notices that are not prohibited are the 4 landlord types that we discussed. So if the landlord is selling to someone who's going to move in, if the landlord or their immediate family member wants to move in, if the landlord is going to demolish the place, or if they're going to renovate the place and it's going to be unsafe for someone to live there in the time during that time, those are reasons that they're called no cause because it wasn't any violation on the part of the tenant, but those are still reasons that the tenant can still be evicted during the moratorium. I hope that clarifies things.
No, yeah, I guess wanted screaming child in the background, everyone. But thank you for that. Yes, I just wanted to, I guess, a little elaboration on that. And I don't have any other questions. I always appreciate it and I'm thankful for all of the information and staying up on, policy updates. So definitely appreciate y'all, Legal Aid Services of Oregon, for offering y'all assistance. What is this, House Bill 4401? And I don't think this is the last one we're going to be having an update on. So looking forward to it all. I'm going to say thank you. Yes.
Thank you, Fendi. Thank you, Ty, for putting this together as well.
Yeah, thank you both so much. Nice to meet you, Diane. Thank you, Mateo, for always giving us the updates, and I appreciate your time. Carly, thank you so much as well. And yeah, thank you all for tuning in. This will be recorded, so please share this video for more legal information regarding this. Thank you all so much. Have a good night.